All right, if you are prepping for the Queensland bar exam, listen up. There are two sections of the Evidence Act you have got to have down cold. Today, we are unlocking those two crucial and, as you'll see, very different exceptions to the hearsay rule, Section 93 and Section 93A. So here's how we're going to tackle this. First, we'll dig into the classic legal headache that started it all. Then, we'll unpack the two big solutions Parliament came up with. After that, we'll see how these rules play out in the real world, and we'll finish up with a super clear toolkit to make sure this all sticks for your exams. Okay, let's jump right in. To really get a grip on these sections, you first have to understand the problem they were built to solve. You know, without the why, the what, and the how just don't make a whole lot of sense. It sounds, well, kind of ridiculous, doesn't it? But this was the exact real-world puzzle the House of Lords was staring at back in 1965. And their decision really blew the lid off a massive and frankly impractical flaw in the common law hearsay rule. So the story goes like this. A guy named Myers was charged with dealing in stolen cars. The prosecution had what looked like a slam dunk case. They had the car factory's own internal records, which perfectly matched the engine block numbers to the specific stolen cars. It was solid, reliable proof, but the House of Lords said, nope. They threw it out as inadmissible hearsay and overturned the conviction, all because the anonymous factory workers who stamped those numbers and made the records weren't physically in court to testify. The judges basically threw their hands up in the air. They even admitted that the rule led to an absurd result in this case, but they felt it was just too late in the game for them to be inventing new exceptions. That, they said, was a job for Parliament. And just like that, the need for a legislative fix, a way to get perfectly reliable, everyday business records into evidence, became crystal clear. And that brings us to our first solution. Parliament heard the call, and their answer was Section 93 of the Evidence Act. This is the direct response to that mess in Myers. You should think of this section as the law being pragmatic. It creates a very specific gateway to get those factory records, or maybe bank statements or flight manifests in front of a jury, but only if two key conditions are met. It's a simple two-step test you have to run through. First, is it a business record? Now, that's defined pretty broadly. It includes government departments, hospitals, things like that. Second, and this is the absolute kicker, you have to prove that the person who originally supplied that bit of information is unavailable to testify. Now, pay close attention here, because these are the only 4 reasons for unavailability that the Act allows. You can't just wander into court and say it's inconvenient to call the witness. You have to prove one of these 4 grounds. You can bet this is prime territory for a bar exam question, so you'll want to have these locked away in your memory. Okay, so Section 93 gives us a neat solution for inanimate business records. But what about when the evidence isn't a number in a ledger, but a memory locked inside a traumatized human being? Well, that's a completely different and far more sensitive problem. And this slide right here perfectly captures the huge shift in legal policy we're about to see. We are pivoting from a rule that's all about a witness being unavailable to a completely different rule that's designed specifically for a witness who is available, but for whom giving evidence in a formal courtroom setting would be incredibly difficult or even re-traumatizing. And that leads us straight to Section 93A. This is a rule born not out of convenience, but out of compassion. It's designed to protect the justice system's most vulnerable participants while still getting to the truth. Look, the whole point of this section is to get a better, more accurate account of what happened. It lets a pre-recorded statement, usually a video interview done by a trained officer shortly after an incident, be played in court as that witness's main evidence. And here it is, the critical point, the complete 180 from Section 93. To use a 93A statement, the witness, that is the child or the person with a cognitive impairment, must be available at the trial. And why is that? It's to protect the accused's fundamental right to test that evidence through cross-examination. This quote from Justice Pincus just nails the justification for this whole reform. It's a recognition of a simple human truth. A child's best evidence is often their first one, given before time, stress, and the frankly terrifying atmosphere of a courtroom can chip away at their memory and their confidence. But it's not a policy without controversy. President Fitzgerald, in a really powerful dissent, flagged some serious concerns. He was worried that we were shifting a core function of the court, taking evidence out of the courtroom and into the police station. It really highlights a deep tension in the law between tradition and this new, modern approach. Okay, so let's get practical. Let's say you're the prosecutor and your pre-recorded statement ticks all the boxes under 93A. It's automatically in, case closed, right? Well, not so fast. Let's look at the real-world hurdles you're going to face as counsel. And the answer to that is a hard no. Getting past the basic requirements of the section is just round one. The next fight, the real advocacy, is going to happen on the battlefield of judicial discretion and trial procedure. If you're defense counsel, your job might be to stand up and argue for exclusion under Section 130. You'd be pointing to things in the video that might create an unfair prejudice, and you absolutely have to remember the jury room rule. A 93A statement is evidence, but it does not go into the jury room as an exhibit. The thinking is there's a real danger a jury might just play it over and over, giving it way more weight than the live testimony they only heard one time. All right, let's wrap this all up. Think of these two sections as two very different, very powerful tools in your advocacy toolkit. And trust me, getting them mixed up in an exam would be a really bad luck. This table right here is your cheat sheet. Section 93 is for documents when the maker is unavailable. Section 93A is for vulnerable people when the maker is available. One's about reliable paperwork, the other is about human welfare. You need to know the witness status, the goal, and the key procedural traps for each. And at the end of the day, that's really the big question these two sections force us to think about, isn't it? They're a perfect example of the law evolving, moving away from rigid, old rules to more nuanced solutions that try to strike a balance between fairness for the accused and finding the truth in the most humane way possible. A constant work in progress, for sure.